establishes a precedent that no one who was intimidated into doing that was required to do it under the law. And I'm going to draw a parallel here because I think anytime a judge does something that's inappropriate or tells somebody that you have to do something that is contrary to law and it results in damages, then who's responsible? The person that's exceeding the law, the person that's violating their oath of office, that has intentionally and deliberately been an agent of, let's see, how's it go? Defending the person who didn't defend the Constitution of the United States of America against all enemies, foreign and domestic. Well, sometimes these people are becoming agents of those domestic enemies. You know, maybe they'll choose to identify some of them. I don't know. We won't know how far it goes. But I think having a familiarity with Clark's case, I think that's what happened. We see it starts small. My friend used to say it starts in the local police department with a free cup of coffee. And soon they're picking up an envelope to allow the commission of drug offenses in your neighborhood. Pretty soon people are whacking other people and picking up an envelope. But it started with that 10-cent free cup of coffee because 7-Eleven wanted the police around their store to cut down on the robberies. And it grew into out of control. Well, that's what we've allowed to happen to the judicial system, folks. And I knew it in my last year of law school. I've had many people ask me, oh, you know, do you have your license? No, I don't, folks. I'm first to admit. I graduated in the top third of my law school class. I worked the last 2 years and a few months since for one of my professors, El Cajon, California. But as far as I'm concerned, right now the system's too corrupt for me to be involved. If I ever did it, though, you know, if you ever see me with a card, it's going to say professional malpractice. And I'm going to go after attorneys that don't represent their clients, because it's a minefield out there, folks, with attorneys. I'm hopeful that we'll get one or two good ones. I know there's a couple of them here in town that are the best. I don't necessarily like their marketing program, but a couple of innovative attorneys here in Las Vegas now are coming with bulk pricing. You know, they'll represent you on a divorce case, and here's what it'll cost. You know, if they win, if they do as good, every bit as good a job as they were going to do, if they were on the clock, then I got no problem with that. But you're going to have to watch them too. You always have to watch the vigilance, it's called. That's the price of freedom and liberty, is eternal vigilance, Thomas Jefferson. And that's what we're doing today. We've got a small group of people. If anybody hears this, a rebroadcast of this show, or hears about it from someone, I heartily encourage you to contact the Radio Tribune, call in, make your email aware of the people that are the appropriate parties. Let's come to some of the public. What are they called? What are they called, Clark?
Defenders?
No, the get-togethers that we've been talking about having.
The town halls.
Town hall meetings. There you go. Yeah, it's good to have two heads that are working on these projects. Right. The town hall meeting. That's where it's at, folks. Where we can ask each individual. This is where you're going to learn some stuff. I can remember when Harry Reid used to have those, but Mr. Irwin Schiff, who should be out of jail here pretty quick, we used to practice our approach, and Harry had one of them, and we had about 10 or 12 people there at one of them, and we bounced him around the room like a ping pong ball. And of course, he didn't know nothing about nothing. He had the Schultz defense. I know nothing. I tell you, he was real good at that. He spent, what, 20 some years, and now he's the head of the liberal wing of the Republican Party, and he's still causing havoc. But he's going to retire, he says. I hope he doesn't change his mind. But we need a little more discernment in our selection process of the people that we trust with with defense of our rights. And the only person that can do it, folks, look in the mirror, is you. If everybody does a little bit, then nobody has to do a lot. So that's my report from the courthouse today. And if anybody has any questions, I'll stick around here a few minutes maybe and see if we get any calls. How is your case going?
Well, I got a question for you.
Okay.
Kind of like burden of proof. The Supreme Court of the United States, we're hearing a lot about that lately with this Kim Davis out of Kentucky, a town clerk that issued marriage licenses, and for religious grounds, she refused to issue license to gay couples that wanted to get married. But the Supreme Court has weighed in on that lately and decided that now marriage law applied to gay couples as well as a man and a woman, and decided to change the law after 120 years of existence. And Kim Davis's job changed her description after she was elected. So that's kind of a dramatic change, and her religious beliefs didn't support that. But the question goes to this: what is the law of the land? And if the Supreme Court makes a decision, does that become the law of the land?
Well, I think in the situation with Miss Davis, I've always been of the opinion that she's not affected by ex post facto law. Even if, I don't care who says anything about what the law is now. She was elected as a representative of the people. If the people decide that she can't do the job, then they should have other representatives take the right procedures to have her replaced. It's my understanding that she was refusing to issue any licenses. She wasn't going to be accused of discriminating against homosexual couples. She wasn't going to issue any with her name on it until the smoke cleared. The best way to do that, maybe she was advised by her attorney to do that. I hope she was. I think it's pretty sound advice. You can't be accused of discrimination if you aren't issuing any. And if her deeply held religious convictions require that she not be a party to issuing a license to individuals who don't comply with her deeply held religious beliefs, then I don't know how she can be compelled to do that. I know that Galileo was placed in prison for saying the earth was round, and whoever was in charge, the king or whoever it was at that time, he knew it was flat because he'd been to the edge. I guess he'd fallen off a couple times, but he always, I guess, swam back. I don't know how you swim back from the edge of the earth, but evidently he came back and he knew the earth was flat, so he imprisoned Galileo for saying that the earth was round. But that didn't make it flat. I think it's still round, and I'm glad that. Thank you for that information on Ms. Davis. I had a feeling in the interview I saw or last saw her, and she said that this situation's far from over, and the way you beat tyranny and oppression is you don't let it set. You don't let that first policeman that you see getting a free cup of coffee at 7-Eleven. You don't have him arrested for that. You just point it out to superiors that sets a bad precedent. The first time that a judge tries something that he's an elected official and all of a sudden he puts on a black robe and treated like he's royalty. I mean, nobody knows how anybody's going to react to that. Of course, do some of them all react perfectly? Of course not. Whatever perfectly is. Do some of them abuse that power and control that they suddenly have? Of course they do. And how do they get away with it, folks? That person in the mirror in front of you, because you didn't do what was required. So
anytime you rely upon humans to do things like enforce the laws or obey the laws or this or that, you're going to be subject to abuse and so forth, because that's humans. They make mistakes. So my issue with Kim Davis was that she has an excuse on religious grounds. Whether that holds water or not, it's an excuse. And what about someone that doesn't have a religious excuse, and there's been a Supreme Court decision that's come down the pike, let's say about property rights between states, for example. Can a property right be taken away by another state? In other words, can the state of Nevada control property, let's say, in New Hampshire? And if there's a case from the Supreme Court that says that that's not possible, is that the law of the land? And are all lower courts from the Supreme Court supposed to abide by that ruling that has been established in this country? Why would someone have a burden when, let's say, a human judge, let's say, for example, does not uphold the law of the land and ignores a Supreme Court decision? What goes in those cases? Why does anyone have a burden to even go back and say, wait a minute, you made a mistake here. If the law is the law and it's in black and white and it's recorded and filed and published, why is that not the law of the land? Or is it the law of the land?
Well, as far as I'm concerned, I think you know my position on that. It is the law, but the law doesn't enforce itself. Constitutional rights are endowed to us by the Creator, but they don't defend themselves. If you don't know them, you don't have any. And I think the only thing is I can respond to try to give you my perception of the burden, because I'm willing to exercise. I don't look at it as a burden. If you aren't having a good time, if you aren't enjoying yourself, if you don't feel like you're doing part of what you've been asked to do for the civilized society that has provided a way of life for you, then obviously try to find somebody else to help you do it, or try to find somebody else that wants to do their case that's similar. Do it. Develop a plan where you don't have to do it, because nobody has to do it. And that's how I've tried to explain. That's how evil succeeds, when good men and women do nothing. I know that I just heard an example of that the other day. I forget the context it was, but he said, it was Alex Jones. He said, the only reason we haven't stopped these psychopaths that loan money to both sides in the wars, that are printing our money, that ran the 9/11 operation, that ran the Vietnam War, killed 58,000. The only reason we haven't stopped them yet, folks, take a guess what it is. Because good men and women haven't gotten off the bench yet. You're sitting on the bench waiting to get in the game. What are you waiting for? Now's the time. Now's the time.
Well, the games are supposed to have laws that people can follow, and I think in this country we go by a principle that negligence is no excuse for breaking the law, that if you don't know the law, that's your problem. You should know the law, and if you violate it, someone may hold you accountable for that. And not knowing it's no excuse. So now we get to the burden situation here, where I consider that when you have to go through a legal process to uphold a law that's already been decided in this case and established by the Supreme Court of the United States, that's an undue burden that someone would have to go through to do this again. I thought we were a law in this a country that went by precedences and stare decisis, that if something's already been decided, why do we have to go through the burden and the expense and the time associated with deciding it again and again and again and again? I thought that's why we had published cases and the Supreme Court of the United States that rendered decisions that do become published and become part of the law of the land, and then all courts are bound and mandated to follow it, so that we have jurisdiction economy and we're not wasting the court's time or people's time. But the lawyers, they have to be paid, right? All lawyers, you have to understand something. All lawyers need to be paid. I heard that in court the other day.
Was that a
from
quote?
A judge.
That was a quote?
That was a judge in district court in Nevada that gave me a lecture and said, you have to understand something, that all lawyers need to be paid. Even lawyers that had no business taking a case to start with and lost the case, those lawyers somehow need to be paid. Now, this is a judge sitting on a bench in Nevada. Now, if you can imagine that as it goes to all cases, let's say now in the country, if that's the case, can you imagine the jurisdiction system that we're going to have where all lawyers be paid no matter what? Well, let's say I just file a case about this or that. Well, I'm going to be paid, so what do I give a shit? All I got to do is file a case. I'm going to get paid. by Judge Gephardt's his name. He has a theory that all lawyers need to be paid, and I have to understand that. Well, here's the problem that I'm having with burdens in this country, is why do I have a burden once the Supreme Court has weighed in on a decision that's in black and white? It was rendered in 1958, and in that decision, they referred to a case that was from 1878, and in that case, they referred to a case from 1811. So for going on 200 years, we've had jurisprudence in this country and established laws from the Supreme Court of this country that one state cannot control property situated in another state. That is the law of the land. It's been the law of the land. Now, why do I have any burden whatsoever to go back and say, wait a minute, you cannot take my property from New Hampshire and give it to lawyers in Nevada? Whether they have to be paid for their light bill or whatever, it doesn't matter, Judge. You broke the law. Now, that lady in Kentucky went to jail. She had religious grounds. What does Judge Gephardt have for grounds? That this lawyer that he doesn't pay might not have enough money in his jeans to give him a campaign contribution? What's going on in this country? Why in the world do we have judges that don't know the law or don't uphold the law? Or they have an agenda to pay lawyers so that they can get a campaign contribution. This sounds like corruption to me, folks. What do you think, Steve?
Well, I'll tell you, you're right on point. What has happened? Corruption. It started with that 10-cent free cup of coffee, and now it's out of control. Who has set an example? Well, Bill Clinton. He didn't have sex with that woman. Just ask him. Oh, you got the proof. Oh, well, it depends upon what "is" means. I mean, these goofballs are setting an example. Oh, these people they just cut in front of everybody and come into your country and take your job and drive down your standard of living. But they're only trying to better their families, Mr. Reed says, just like the bank robber. I think anybody in jail right now should file a petition to get out of jail. They were just trying to help their family, better their family. If a couple people, bank attendants, got shot or killed, they took their chance. We have no, and what possible respect for the law would these people have that come to your country, jump into the front of the line? They're here illegally. That one young lady over there on the pier that got shot by one of them that had been deported 5 times. He found the pistol. It just accidentally went off. What kind of a defense is that? I don't believe that's going to stand up. But what kind of respect do people like that have for the law? Now you got judges that have been abusing their situation. You got district attorneys and public defenders. The way they control the public defenders, if a top-notch attorney can handle 20, 25 cases, say a week, they give him 50. And if he manages, although I imagine most of them are on salary, if he manages to handle the 50, give him 75 next week. Just get him to the point where he can't do his job because they don't deserve these accused. They're guilty, or they wouldn't have been charged. And unfortunately, the last time I was in a jury trial, I was there with a retired policeman detective, and after we heard the shooter, the policeman that shot the individual, a gentleman that I've become pretty good, close friends with, shot him 3 times. It was an absolute miracle he wasn't killed. He was brought up on charges. He had already filed a civil suit against the shooter for abuse of legal force, because how do you get shot for a burnt-out headlight? Is that a capital offense? He got shot 3 times. It's a miracle he didn't die. And he's up on trial. And you want to hear the clincher, folks? He's found guilty after the policeman lies under oath, explaining why he shot him. And when my friend, the retired policeman and detective, he says, "Oh my gosh." I said, "That didn't sound good for the policeman." He says, "No, he's going to lose his pension. He's going to have to, his prediction was he'd have to retire, otherwise he'd lose his pension. He wouldn't be on the police force after that." Well, I guarantee you when the jury came back guilty and convicted the man that got shot, I guarantee he's still on the police force. Because there were no repercussions. But there should have been. The jury said, heck no, we heard that guy lie. How can we possibly convict this guy? We can't. You know, people were in absolute upheaval when they found O.J. not guilty. But how many people are guilty and are found, or not guilty and are found guilty? I know I've read some of the biographies of some of the top defense attorneys in the nation through the years, and every one of them say it's not even close. Way more people are found guilty that are innocent than there are that are guilty and are found innocent. It doesn't go that way, folks. Stop going for the programming. Tune off your TV, turn on Radio Tribune. In about a week or 10 days, your brain will start functioning again. You can start calling in area 702-983-0711. You can come to the public town hall meetings, and we can straighten out this country. You want change? This is your chance. Because I can tell you, these people you're electing, that's a false hope. If they give you change, you're not going to like it. As far as the problems that they inflict upon you, the burdens that they impose upon you, one of the first things that I still will always have faith in it, no matter what happens. The law will always, not most of the time, not a high percentage of time, not almost anything. The law will always give you a remedy. You may not choose not to accept it or not to take it on. I've been in that situation myself from time to time. I'm struggling with a case right now that I don't know whether to go forward on it or not. And I don't have to. But see, if I don't, then the next person who falls victim to the defendant in my case, the next person that he takes advantage of or cheats on or abuses, I'm helping him do it because I didn't teach him a lesson. I guess that's the moral to the whole story. Is it a burden? Of course it's a burden. Should a judge do that? Of course a judge shouldn't do that. Are they out of line? 100%. Is it a tremendous burden? Yeah, but if you don't do it, who's the next person that's going to fall victim to that? That particular judge that you made reference to, I have a contact with him, and I just haven't got my case done against him yet. He shouldn't be where he is. He was a justice court judge. He saw an opportunity because of the support, nothing really bad coming out about him. He saw an opportunity to advance. Well, that's the American way. So he ran for a higher position, and he got it. And now I hope in the days ahead he'll go back to whatever rock he crawled out of from under. And I hope he learns a lesson not to abuse people, no matter how much power he has. And that's all we can hope for. We have to hope that we're doing our best. And I know he shouldn't be where he is. He shouldn't be hearing your cases. But he managed to speed up the process, and he got into a very, very high-profile case with a lot of money at stake, and he doesn't know anything about it. And that's an awful combination. I'm not sure about his intelligence. You can remember, a lot of the people that go to law school, half of them are in the bottom half of the class. I can't make any representations regarding. Usually, I will offer this. So I've always heard, that's part of your herd there. I've always heard that judges make some of the highest grades in law school, that they were the ones that really make the big money. Then there's the law professors. And then there's the average students that the judges make money in a profession. And then the law school professors and then the run-of-the-mill attorneys. And the attorneys if the economy is good, they're the ones that make the money. That isn't the case now because we're allowing other abuses to exist. This is a multi-headed hydra, folks. Just because you aren't affected by the one you're listening to today, I'm encouraging you, hey, don't wait till it affects you, because if you don't care about the people that are being affected now, who do you think's going to care when they come for you? There was a saying like that in Hitler's Nazi Germany. When the Nazis came for certain segments of the society, if it wasn't you, then why would you worry about it? Well, who was left to complain when they came for the guy that didn't want to worry about it? So that's all I can ask you. I think if you can get to where you accept it as a public service, I'm not saying that you have to be happy about it. I think the law will always give you a remedy. I think that remedy is available to you if you learn how to do it. The case is over when you say it's over, and your case has got a ways to go. If there's anybody in our listening audience that is good with writs, and in lieu of an appeal to the state Supreme Court, I know that it's a very specialized area of the law. I admit I don't know much about it. I had one experience with a writ, and I was unsuccessful with it. I don't know. It was a bank mortgage fraud situation, which Ron Williams was there this morning. I'll give him some publicity because it's my understanding he's going to be on Friday again. He likes doing the Friday show. I invited him to come over to the studio today, but he said he was going to wait till Friday. And he's just super sharp. I like him. He's part of the solution. And if you're part of the solution, then get off the bench and get in the game. It's pretty easy. Nobody's going to criticize you. Just develop your discernment. Develop a plan of approach. Share your plan with other people. And ask them for their inputs. Listen to what's said and what other people think might be right. I've seen people take the same approach into the courtrooms and coming up with two different decisions. Now, what's the logical explanation for that? It's the same words on both cases. One guy's presented it in a little bit different environment. He was a little more respected, perhaps, by the judge. The judge had a bad day on the one case where the judge ruled against it. I think your original judge was about to retire, probably should have retired, probably the election cycle before, but it was a cushy job. He was the incumbent. He hadn't done anything wrong. He probably didn't have much opposition, and he was returned to a position that he probably shouldn't have been in. I mean, I know you don't want to hear that. Nobody wants to hear it. But that's my take on it. I originally told you that when I went before him, I thought he was more than fair on my case. But one of the attorneys I was working with was providing him with all the backup material from Anderson's on restatements and all the law that supported the phony foreclosures that Ron Williams is bringing cases on. So, of course, that judge was up on the law in my case, and I thought he was more than fair. I think he recognized the fact he didn't know anything about your case, and he made a mistake.
Well, that's my point. The fact is that we have to have laws that are in black and white. We're a law of precedence, or a country, I think, of precedences, which makes sense to me that if a case has already been decided, and there's nothing wrong with the precedent, I mean, and it's upheld again and again and again and again, then that seems to be a pretty good ruling. The original one that keeps getting upheld, so shouldn't that become part of the law of the land, especially when it comes from the Supreme Court? The Supreme Court has overturned themselves, I understand, like 135 times. They have things change over the time. Maybe 100 years goes by and something's not applicable anymore. And they should change a previous ruling because it doesn't apply. Maybe they got something dramatically wrong before and they change it and correct it. But the law of precedence is judges are people, and judges make mistakes, and judges can be incompetent, and judges cannot be up in the law. And this judge in particular, that was in my case, made a statement in court and closing arguments that he had no experience in trust law. He didn't know anything about it. He never handled a case in trust law. So how was this a guy that had just sat through a case as the judge in charge, and he went through 6 months of trial, and at the end of the trial he says, I don't know anything about trust. I mean, to me, that is not a judge that should have been sitting in the case to begin with. And didn't he know that? He said the statement at the end of the trial. He must have known the same thing in the beginning. This is a judge that doesn't do his job, or the robe's gone to his head and thinks he can walk on water and do whatever, and he has no concept of the devastation he's causing the people before him when he doesn't know anything. And then both sides in this particular case, the plaintiff and the defendant, specifically told this judge that you do not have authority to sell a home in another state. Only the state where the property sits can sell a home in that state control title. And that's what he was told. 11 months later, he comes out with a ruling that's completely opposite of that. I mean, this is not a judge. What is this? And why does someone have to go through the burden of saying this guy was wrong? He is wrong. It's black and white law that he's wrong. He was told he's wrong. Why do we have a burden when a mistake like that happens that's obvious of what we have to go through to straighten it out and the expense and time that's done in the process? Something has to change. There has to be some sort of an overseer, not the Supreme Court, they're too busy, or they have to get to a point where they can quickly decide cases and not take 3, 4, and 5 years for the Supreme Court to render a decision on a case that could have been a mistake. That's ridiculous. Let's get some people sitting on whatever tribunals they got to sit on, and let's get these cases decided and move quicker. Why the hell are we waiting years for a decision to come down? Can anyone explain that?
Well,
are we that busted?
They put in an appellate level, so things are going to speed up. I know, as I heard you say things change, I think an excellent example of it right now is Roe versus Wade. I think with the publicity attached to Planned Parenthood regarding the slaughter of small babies, I'm sorry, they aren't babies, they're fetuses.
No, you're only a child when you leave the hospital. According to, was that Pelosi, I believe, if I'm not mistaken?
Yeah, well,
Pelosi. Hillary, I don't know.
Pelosi also wants to take all of the refugees too, but I haven't seen the news report of her taking any people into her house. But she wants to spend your money to get them here, though. But I think that's an excellent example. One of the electives that I took was appellate advocacy, because I knew that I would be handling appeals from time to time, because my constitutional law instructor said you may get yourself in a situation where you're doing everything right, and because of good old boyism or the way we've done things here for years, just the stone cold the abuse of power, they aren't going to let you win. Then the last thing you do is you pitch your bitch to the public. I've said that's why I'm here. Because, folks, I'm going to go somewhere else. Because Judy DeGeneres said, you pitch your bitch to the public, and if the public doesn't care, go somewhere else. Because those people aren't worth trying to save. I know there's a lot of good people here in Las Vegas. I've met all of them when that came out when we had one of the talk show cities in the nation, people who really cared. One of the reasons that I immediately see as far as straightening things out is due process. The level of accusation that you've expressed and I agree with regarding the judge in your case. If I want due process, I better give him due process. I wouldn't want him hauled out in handcuffs until you have a slam dunk criminal case ready to be filed against him.
What is a Supreme Court decision? And that's the law of the land. What is it? Kim Davis went to jail. She was hauled out in handcuffs.
Right?
She violated the Supreme Court decision.
She violated a court order by a federal judge to do something that he said she was required to do. We don't know if she was required to do it or not. I don't look for the federal appellate level to uphold that incarceration. I think she'll be paid for that incarceration. That's my take on it.
Well, there's court orders, and then my understanding is there's court orders that are voidable, which means you have to go through some sort of a process to get them declared void. And there's other court orders that are void. The ones that are void, no one should have the burden to have to prove they're void. They are void. So anything that goes against a Supreme Court decision, which is the law of the land, is a violation of that particular decision, to me, is void. You shouldn't have to do anything. But in my particular case, the thing that was done over and above the trust application of this particular void ruling could be void. That's fine. I just ignore it, which is what I did. I got a cashier's check to protect the trust assets because I knew this judge had gone off the rails and was doing orders that were void. For example, he found me in contempt of court in Nevada, and he tried to have me arrested in New Hampshire with a contempt of court order from Nevada. Well, there's a Supreme Court case called Huntington versus Atrell from the 1800s also that makes it unconstitutional where one state cannot uphold a contempt court order from another state because that's a violation in a particular state that's against the state. Well, you can't be held accountable in one state for something you did in another state against the state. That's only can be done in that state. So that was another void order that this judge had the wisdom of doing that was illegal. But anyway, he ends up going to the avenue of stopping payment on a cashier's check, which you can't do. So this guy was over the top. So I had him blocked on the trust case. I had him where he couldn't do anything there because it was a void order because of the U.S. Constitution. And then he turns around and commits bank fraud by stopping payment on a cashier's check that's as good as cash and can't be stopped. And that's a federal law.
He retired.
And then he retires and goes to the house. Or he decided to have health issues and not run again, maybe, who knows why. But the person has some serious problems because he made a mistake. He made a mistake early on in a case where he allowed an attorney to make representations to him that were fraudulent because the judge really didn't have any experience in what he was doing. And the lawyer was making references to the fact that my case was not valid because I sued a person individually instead of suing a trust. Well, I knew, here I am a layman, I'm not a judge, I'm not even a lawyer, but I knew that I couldn't sue the trust before I filed a case. I did research. You can't sue a trust. A trust is not an entity. And I could not sue a trust in Nevada because guess what? The trust wasn't from Nevada. It was from New Hampshire. So you can't sue a trust in Nevada that's from New Hampshire. It won't work. It would have been thrown out of court immediately in front of a judge that knew the law. But this attorney that took a case he never should have taken because he had a client with no money that couldn't pay him, but he saw a $2 million price tag on the trust that she was representing. So he went, oh boy, I cannot have to chase so many ambulances in the future. So I'll take this case. Well, he forgot to figure out how he was going to be paid. So he went to a judge. He said the case was fatally flawed because I did not abide by a trust law provision. When you sue a trust, you have to notify all the beneficiaries of the trust when you sue the trust. The thing he forgot, and the judge couldn't quite comprehend, Judge, I didn't sue the trust. So a statute regarding trusts does not apply when you don't sue the beneficiaries of a trust that you never sued. So come on, Judge, let's try to get it together here. He made a mistake. He instructed my attorney to change the case and include the trust. When he did that, not only did he include the trust, he included all these beneficiaries as defendants, which were innocent defendants. They didn't do anything wrong. I got no case against them. So now we got innocent defendants being represented by a defendant attorney who's got these new clients now because he made them defense clients. He made them charged with a crime, so now he can defend them. what a great deal this is. What a great judge this was. So he made a huge mistake to start. And then as time went on, he had to make mistake after mistake after mistake, trying to survive from the first mistake he made. And he just kept getting in deeper and deeper and deeper. And by the end of the day, I knew the law. What did I do? I blocked him. I checkmated him because I sold the house in another state, which I had every right to do. There's laws in Nevada, the laws in New Hampshire, the laws all over this country dictate that a trustee has to do everything in his power to protect the corpus of a trust. That's his responsibility as a trustee to all the beneficiaries. And that is by statute. He has to do that, and that is defend all inalienable attacks. And an inalienable attack is considered any attack from a court that does not have jurisdiction. This court did not have jurisdiction. A court in Nevada will never have jurisdiction over assets in New Hampshire. It just doesn't work that way. Now, a judge in any court in the land can make a ruling if there's a case before him as the forum court. He can make rulings, but the issue comes down, are they enforceable in another state? Well, this one would not be enforceable in another state because the Hansen and Deckler case that I'm referring to that came from the Supreme Court specifically mentioned the fact that long-arm statute of the law, where one law, one case in one state has to be applied in another state or enforced, does not apply to property, real property, or trust law when you're going between states because one state cannot control the trust law of another state. So that goes out the window also. This judge had no authority to do what he did. Both attorneys in court in front of him told him he didn't have the authority to do it, but he's the judge. He does whatever he wants. Every ruling I make in this courtroom is the rule of law, he said one time in one of the famous lectures I've been famous to get lately, like Judge Gephardt. You have to understand something. All lawyers need to be paid. You need to understand that. Yeah, well, that's not the case, Judge. And, you need to go back to school. You need to get the hell off the bench while you do because you're not capable or competent, in my opinion, to be sitting on cases in Nevada or any place else. So anyways, this judge went off the rails, and I look at the burden of proof or burden of whatever is being placed on my shoulders in two avenues. One is the judge makes an invalid, void ruling against a corpus of a trust that's in another state. You can't do that, period, case closed. That's been decided by the Supreme Court of the United States. Over, done with. The other thing this judge cannot do is stop payment on a cashier's check, which is what he did also. He induced the bank to not honor their binding commitment to pay an obligation that they had to pay this check, and somehow he enticed them to send the money to Nevada, which this bank made numerous errors because it was trust. Again, you can't do that either, but there you go. Steve?
I noticed there was an article, an updated article in the Las Vegas Tribune on your case. Have you had a chance to take a look at that? Have you read that?
Yes, I certainly did.
Could you give us an update of that and tell us where we could read about it? It's LasVegasTribune.com. Is that?
You can go to LasVegasTribune.com and you can look up yesterday or today's article. I guess it came out this morning.
Hot off the press, folks. Here's where you need to go.
And it's an update on. This is the 8th story, I believe, on 7 previous stories that were reported for the Tribune. It interviewed me and my son, my older son, and gave them details and so forth of what's going on. Of course, they check out the information and verified that the law was, the way that we portrayed it and so forth, and decided to write articles about it. And that's what's done. The 8th article hit the press today, and it concerned a lot about the bank check and the status of what's going on there. Right now, my oldest son is back in Connecticut in front of the bank. On the radio.
How is that going?
Well, it's very interesting. He's called in a couple of times and given us some updates. He's gone into the bank, and everybody now at the bank knows him. He's got a lot of exposure.
Anybody from the bank come out and say hello, or what?
Well, there are some people from the bank. There's the branch manager there, which is just a manager of that particular. This headquarters is what it is, but like most places, they do have a branch in the bottom floor that takes customers in and out, but the branch manager there comes out and talks to him now and then, and he's made it clear that his opinion anyways, and whatever that's worth, is that something needs to be done about this, because what was done, obviously there was a
something
mistake
is
made.
Being done.
Yeah, he says, obviously there was a mistake to be made, and I think that From what I hear, the legal department is looking into this or whatever, so that's some of the response there.
How about
And
the
then,
news reporters?
he was interviewed by a TV station there that I guess they end up, it was a tape thing, and then they end up producing it and putting it on whatever their channels are that they use. There's also...
Have you got a clip of it yet?
No, we don't know, but he's going to get one, of course. They edit it and they do whatever. And there was a party there at the station at the same time that's running for mayor back there in Bridgeport, Connecticut. And he had a lot of interest in this case because, first of all, he, I guess, has a legal background, and he knew there's a couple knowns in this world. Not many of them, but there are a couple. And anybody listening, anybody can go to any banker and ask them if they can stop payment on a cashier's check, and they'll be emphatically told, no way. You're kidding, you know, this can't be done.
Yeah, you showed me that case with the Sands, where the bank just deposited the money and was held additionally liable for not paying off the amount to the people with the cashier's check. Just
Right.
depositing the money into the bank wasn't good enough.
Right.
The court told them that you violated these people's rights when you withheld their money. I read that court. I read that case.
Every precedent that I've read, and I've read a lot, there aren't a whole bunch of them because this is not something that's done often. As a matter of fact, I cannot find one precedent in the state of New Hampshire where a bank has ever stopped payment on a cashier's check, at least through the courts anyways, that has risen to the level where you can find a published opinion. So either it was, if there was something where that happened, it was settled real quick and never rose to a level to where something gets published. But there's never been a case in New Hampshire that's gone to a higher court to be decided. And every precedent that has gone that far, never has been a case gone to the Supreme Court because the circuits always straighten it out first before it gets to the Supreme Court. And every circuit court opinion, the bank always loses. Always loses. Now, unless there's some extenuating circumstances that don't exist in this case, because the banker knew I was a trustee, I had put the money in the bank, it was good funds, and I wanted to protect the money. The banker knew why I wanted to protect the money, and the banker recommended that I get a cashier's check because that's better for me than carrying around $1 million in cash. So I was a
you'd have had to buy a briefcase, no question about that.
Right. So anyways, that was his recommendation, and that's what I followed. So now the bank turns around, and an officer at the bank obviously got bribed somehow to stop payment on a cashier's check.
Well, he was given an indemnification agreement.
Well, the law is very specific, and it's a federal law, and they have remedies for when things happen and so forth. And I could have gotten a check from the banker, and I could have proceeded like I do with most everything else in my life. I walk somewhere and I immediately lose whatever was just handed to me. So I could have bona fide lost the check. In that case, there should be a remedy that I can go back and say, hey, you told me to take it instead of cash. I may not have lost all the cash, but I lost the check. So you got to give me another check. Well, even in that case, the bank has to protect themselves. And they have to make sure that I'm being truthful, that I haven't just cashed a check somewhere. So they got to give, they make sure that you sign an affidavit swearing to the fact that you lost the check. Now, the person that can sign that affidavit is the person that got the check. Now, if I gave the check to someone else, I have to disclose, well, I don't have that, I gave the check to Joe Blow over there. Now, Joe Blow could sign an affidavit that he lost a check or whatever. But in this particular case, nobody lost the check. Believe it or not, I haven't lost it yet. I still have it. So that's not the case. But Judge Earl, in his wisdom, with his crooked lawyers and so forth, and this banker that got paid off, agreed to accept an affidavit and an indemnification agreement whereby everybody swears that the check is lost, destroyed, or stolen. Now, part of the description of stolen is an unknown person, I'm not unknown, or in a person not subject to process of service. Well, that isn't me either, because I am before the court. I was the plaintiff in the case. I'm waiting for a final ruling in the case. and which hasn't been rendered yet. I'm a primary beneficiary. I won the case as the prevailing party in Judge Earl's ruling, where he removed my sister as trustee. So I prevailed in that case. I'm listed on the case as the judgment creditor. So everything is in my favor, that I am absolutely 1,000% bona fide to have that check. And also, I am the trustee by law in New Hampshire because I'm listed in the document as a successor trustee. I'm named in the document. So that makes me trustee. So for this court and these lawyers to perpetrate a fraud before the bank and have the bank accept it is absolutely a distortion of the facts of this case, and it's fraud. So everybody in this case committed fraud, including the bank officer. Well, that's made the bank now liable for double indemnity because in their wisdom they sent money out here to Nevada that the judge immediately dispersed to all the lawyers involved. And that's despicable, but of course that feathers up the campaign contributions, going back to the legal system, this corrupt system in Nevada. So that's where it is. And the bank is going to have to end up paying this check. In the meantime, the remedies are that they're going to be liable for interest, they're going to be liable for expenses, and they're going to be liable for consequential damages. So the money's mounting up, and that's one of the things that my son is back there in Connecticut explaining to all those people in the bank of exactly what's going on. He's explaining it to the TV show that he was on, and he's explaining it to the newspapers there in town, who apparently are talking to him and interviewing him and getting ready to publish something there too, I think. So things are really moving back there. There's a couple lawyers that have contacted him and so forth. The remedy, as explained in this particular law, the UCC regulation, is the bank is responsible for all expenses. Well, that includes legal fees. Now, if you get a lawyer that takes a case on a contingency basis because it has a good chance of getting paid, in this case the law's behind them, and the bank is going to do what? It's going to have to pay his contingency fee. Now, a normal contingency fee can be anywhere from 33 to 40%. So if they get a deal going with a bank, a lawyer to work on a contingency, that bank's in a whole hell of a lot of trouble because that contingency fee could be $500,000 in addition. And that doesn't come out of the cashier's check, that's added into it because they have to pay expenses. So there's a legal fee here that could be very, very productive for whoever takes this case. So there are people now beginning to pay attention to what's going on. They've checked the law. The law is right on our side. No one has ever said one thing about the law not being with us. And every precedent that I've found, every single one, the bank always loses, always loses. So there you go. That's the update, and we're almost out of time. If you'd like to close with some comment, Steve, be my guest.
Well, I'd like to thank you for inviting me in here today to share my experiences in court with my court watching group. And I think that we've shared with you some information of what two down-to-earth Americans do when they